Good evening. We're going to call to order the Colerain Township Board of Zoning Appeals meeting for Wednesday, October 22nd, 2014. We'll begin with the Pledge of Allegiance. So please stand and join me.
Pledge allegiance to the flag of the United States of America, to the republic which stands one nation under God, indivisible, with liberty and justice for all.
For those not familiar with the board's processes, I'd like to provide a brief explanation. The following will be the procedure for hearing appeals this evening. The appeals will be heard first, then the other business of the board will be conducted. You may stay, but are not required to remain after your appeal has been heard. All who will testify or speak will be sworn in as a group or individually at the discretion of the board. When you address this board, you must provide your name and address for the record and speak into the microphone, as all of our meetings are recorded. If you do not, your input may not be recorded, and all who testify may be subject to cross-examination by an attorney. All documents, photographs, and other physical evidence presented will be accepted by the board unless withdrawn by the offerer or an objection is made as to the admissibility of the documents or photographs or other physical evidence. The chairman will rule whether those items being offered will be accepted or rejected. The zoning administrator or staff members will present a brief summary or statement of each appeal. The appellant will then be given an opportunity to speak and present his or her evidence. Anyone else in favor of the appeal will also be given an opportunity to speak. Then anyone opposing the appeal will be given an opportunity to speak and present his or her evidence. And depending on the circumstances, the board may impose reasonable time limits given to each side. After presentation of both sides of each case, the public portion of the input for that case will be closed. Any board member may then ask any question of anyone who has spoken or made comments on the appeal. After this discussion, a motion and second will be made by the board to either approve or deny the appeal. The vote tonight is referred to as a straw vote. Such a vote brings forth a resolution at our next meeting reflecting the board's decision. Adoption of the resolution next month is the final order of the board. We acknowledge that issues before the board can become heated and sometimes emotional. However, no disruptive behavior will be tolerated, and anyone acting in a disruptive manner will be asked to leave the meeting. And we'll begin with a roll call, please.
Mr. Bartold.
Here.
Mr. Martin?
Here.
Mr. Price?
Here.
Mr. Roberto?
Here.
Mr. Reininger?
Here. So at this point, anyone who is going to speak to the board, I will ask to stand and raise your right hand to be sworn in. Okay. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in matters before the Board of Zoning Appeals? Say, I do. Thank you. The first case is BZA 2014-24. It's an appeal appealing the denial of a zoning certificate for an alternative financial service provider on section 3.3.2, and its location is 8619 Colerain Avenue, Cincinnati, Ohio. The applicant is Drummond Financial Services, and the owner is 8635 Colerain LLC. The comments from the chair before we proceed. In the last 30 minutes, the board has received probably close to 100 pages of documentation prepared by the attorneys in this case. They look to be very complete and will be very pertinent to this. In the last 30 minutes, I have not had a chance to look at all this and give it due justice. I'm going to ask for a motion to table this hearing so the board can look at what we have and at least be responsible in reacting to it. The board motion is not debatable, but I will ask for a roll call vote.
No discussion at all?
There's no discussion.
Okay.
If there is no second, then the motion will die for lack of a second.
I'll second the motion. Matter of privilege, then, can I speak at all?
According to parliamentary procedure, and I'll read it. I'll read you the parliamentary procedure. To lay it on the table, which is what I'm asking to do. The object of this motion is to postpone the subject under discussion in such a way that it can be taken up at some time in the near future when a motion to take from the table would be in order. These motions are not debatable or amendable and requires a majority vote. And that is
Perhaps,
from parliamentary.
since there is some interest in having a conversation about it, maybe if you withdrew your motion just for a minute and allowed other board members just to,
Okay,
would that be?
I can,
I think council, I mean, I'm not trying to be a pain in anyone's butt here, but I do think there's a lot of people here tonight, and I just wonder what kind of disservice we're going to do by postponing it a month and making them all come back or making council come back. That's my only concern. So I'd rather hear from the audience members and maybe council as to what they think about tabling the motion.
You know, another option that I just came to mind, I hear your concern about being able to review all of the documents. You don't have to come make the motion tonight, correct? You don't have to come to the conclusion tonight. Perhaps tonight is an opportunity to hear evidence. Not all of the evidence, perhaps because you haven't had a chance to review what's in front of you, and then maybe we table it at the end of hearing some evidence.
I think that's a good solution.
I'll withdraw the motion. We'll proceed then. Okay, let's do a staff presentation first.
All right, gentlemen, the case before the board this evening is an appeal of Drummond Financial from the decision of the zoning administrator, me, to not issue a zoning certificate for the use of the subject property as an alternative financial service provider in the B2 General Business District. Our slides here show just the general location. We have Colerain Avenue running north to south. Behind the property is the Bowerwood subdivision, and we're north of Cross County Highway. The zoning on the property, again, is B2 and is directly adjacent to R6. So what's going on here is on March 19th, 2014, the applicant, Drummond Financial, submitted application materials to our office. For the application that was submitted was for an interior alteration. When we took a look at the application, it became clear that actually what this was a change of use. So a change of use zoning certificate has more requirements than an interior alteration. So our office contacted Drummond Financial or their contractors and explained to them that there are other materials that are required for this zoning certificate application. In particular, there is a landscaping plan and a lighting plan that is required in addition to the site plan that you provided for your interior alteration. From that point in time till now, we still have not received a complete application for this project. In July of this year, we received a landscaping plan, but we still have not received a lighting plan. And so the application is not complete. Now in August, on August 12th, in fact, the trustees passed a one-year moratorium on alternative financial service providers. And in that resolution where the moratorium was adopted, it identifies and defines what an alternative financial service provider is, and it is a number of things. It's check cashing businesses, it's payday advance or loan businesses, pawn businesses, money transfer businesses, or car title loan businesses. And then the car title loan business is actually defined further to say a car title loan business shall mean an establishment that makes small, short-term consumer loans that leverage the equity value of a car or other vehicle as collateral. This excludes state or federally chartered banks, savings and loan associations, or credit unions engaged primarily in the business of making longer-term loans, which make loans that leverage the total equity value of a car or vehicle as collateral. In subsequent to the passage of the moratorium, representatives from Drummond Financial came into our office and asked, hey, what's going on? I explained to them that there was no complete zoning application, provided them a letter, in fact. And I'd like to read that letter that I gave them on August 20th. addressed to Drummond Financial, to whom it may concern. Please be advised that a moratorium on alternative financial service providers was passed by Colerain Township Board of Trustees on August 12, 2014, a copy of which is enclosed. Although numerous attempts have been made by our department to your representatives requesting additional information required to issue the permit, the application remains incomplete. Therefore, with the passing of the moratorium, we are unable to issue a zoning certificate for the referenced property. What's going to happen tonight is the applicant is going to ask a number of questions of me and others. Scott is going to ask a number of questions of me and others. And at the end of the day, there will be lots more information that's going to be given to you tonight. But at the end of the day, my findings of fact in this case are that Drummond Financial failed to submit a complete application for a zoning certificate to this day. And number two, the Colerain Township trustees approved a moratorium for alternative financial service providers, which includes the use that is proposed by Drummond Financial. That really is the long and the short of this. And this may be a very lengthy conversation that we're going to have tonight. But at the end of the day, that's my opinion. And my recommendation to you all is to deny the appeal. Now, I think with that, we can move into the next stage.
Okay. Thank you. The applicant, I'm sure, is here. Yes.
Thank you, Mr. Chairman. My name is Mark Elser. I'm with Colerain in Cincinnati.
Your name again, sir?
Mark Elser.
Is there a light
Back
on
it
there?
up. Yeah, it's green. Is that all right? Can you all hear me?
Mm-hmm.
Okay.
You might need to come.
The magician spoke in the back of the room here.
Pay no attention to the man behind the curtain.
That's the Wizard of Oz back there.
Mr. Chairman and panel members, we certainly appreciate your time in hearing our appeal. And Mr. Chairman, I appreciate the fact that you would like to look through all of the materials, and I think this is a good solution to give you all an opportunity to look at it, because I have with me Stephen Marks from Drummond. He's a representative up from Atlanta. And I have Greg Hill, who is our contractor, H&H Contracting, and he submitted, all of the materials. We have submitted 3 affidavits, so we've got testimony under oath with exhibits, attached, and certainly there is going to be some, conflict in the evidence, but to be, I guess, right to the point about it, in March of 2014, we submitted an application. That application had drawings, construction drawings, and a site plan attached to it. When we asked for documents under Freedom of Information to come back, what came back from the zoning department was simply the first page of the application and nothing else. But as Greg Hill states in his affidavit, and he'd be happy to answer any of your questions, we submitted those documents. Within about 5 days, as Jeff says, the zoning department came back and said, hey, you need a landscaping plan and a parking plan. Now, there's nothing on Drummond's side that said that they also said lighting. Everything at Drummond was you need a parking plan and a landscaping plan. That's fine, that's cool. In July 18th, now we had our architects do that. July 18th, Greg Hill submitted the landscaping plan and the parking plan. When we asked for those documents, those never came back either. They're in the affidavits, they're in the stuff, that we gave you, and Greg Hill, testified in his affidavit that on the morning of the 18th, 10 a.m. in the morning, he dropped it off here and put it in the hands of, the zoning department. From that point, according to the zoning resolution, the zoning department had 5 days to rule on the application. And if we were not complete, then they could deny it and say you're not complete. Or at some point, tell us that we're not complete. This is July 18th. But we had nothing. Greg Hill called them 4 times. Nothing. We've asked them since for records because that letter states, I've tried to contact you. We've said, okay, show us the records. Give me an email, a letter. Give me telephone records. Any time that you tried to reach out after July 18th, and we've got nothing. July 30th, the records will show, is when the zoning department sent a memo to the Board of Trustees recommending a moratorium on essentially payday lenders and other lenders of that sort. Again, This happened while our application was pending. No word, hey, we need a lighting this, or we need better parking that, whatever. We got nothing. August 12th, the trustees passed the resolution containing the moratorium. Now, the moratorium is interesting because it defines an auto title lender. And that's the only provision, I think everybody agrees, that's the only provision that could even remotely apply to us, is the auto title lender. I don't think that's disputed. It is? Oh, do you mean there are other portions in there that you think apply to us?
I think that could be disputed, yes.
All right. In any event, all of the all of the definitions refer to lenders or persons or entities that make loans. Drummond does not make loans. We broker loans. We are much more in the nature of a loan broker. We assist borrowers in getting loans from lenders. In Ohio, for example, we use Integra Financial. So what would happen in the loan transaction is that the loan is between Integra and the customer, collateral documents, Integra and the customer. Integra places its lien against the car. If it's secured, we do unsecured loans too. Drummond is not a loan. Drummond does not make loans. In fact, Drummond is specifically defined under Ohio law as not a lender. It is a credit services organization under Chapter 4712. It's not a short-term consumer lender. It's not a small mortgage lender. It's not a lender under 3712. It is a credit service organization, and we've included the chapter the relevant provision in Mr. Waco's affidavit, and Mr. Waco, who's the president of Drummond, defines specifically in his affidavit what they do and what they do not do. But in order to get certified and licensed and to register with the Ohio Department of Financial Services, you cannot make loans. So you can't become a CSO if you make loans, period. And we're certified as a CSO. So Ohio has said, you obviously don't make loans, so you are a CSO. You're not a small mortgage lender. You're not a consumer lender. You're not a payday lender. You're not any of those other things. You are a CSO. Now, the trustees passed the resolution. The resolution, as Jeff says, was passed on August 12th, but it wasn't effective on August 12th. No resolution, non-emergency resolution, is effective the day it's passed. So this resolution wasn't effective until September 12th. And yet, he delivers a letter to Drummond's employee, Eddie Edwin. His affidavit is in. That says, first, you're not complete, but it doesn't tell us how we're not complete. And now we're 25 days past his 5-day deadline. But he doesn't tell us how we're not complete. So first, you're not complete. Second, a moratorium's been passed. Now, the moratorium is not in effect. And so rather than say, we need a lighting, plan, or if you drop your landscaping or parking plans off to us, we didn't get them, or we misfiled them, or what have you. Literally, we've got 23 days before that moratorium is in place, and that is not said. So in fact, what is said is a misrepresentation, and that is that this moratorium prevents us from issuing a zoning certificate. That's what the letter says. As I said, we have affidavits of that to that effect with the exhibits attached, and we certainly appreciate the fact that the board members and chairman are going to want to read those things. But that in fact is the essence of the case. Quite frankly, if we're incomplete in some fashion, Drummond has 2 other stores in Colerain. We've never had a problem. We've got 120 stores in Ohio. We've never had a problem. If a zoning administrator says, hey, we need this, or you need to push that back, you need to put that over there, or I need something here, this is not a problem. But what we're told is that the moratorium is in effect, and it applies to you. So what's irrelevant is I think, I mean, certainly we think we're complete, but, if we're not complete, we can get there in about 30 seconds. The critical feature of this is, does the moratorium apply to us? And even if it does, was it in effect on August 20th? August 22nd is when our employee actually was here. That letter, by the way, never got mailed. Our employee had to come into the building and say, hey, what's going on? And that's when Jeff handed in the letter. Not sure why it was sitting in his outbox. But, essentially what we have here is application of a moratorium that does not, by law, apply to us. And, when I was talking with my very good friend Larry Barbieri, Scott's boss, and I mean that sincerely. I practiced law with him for 30 years. His only comment was, we think that you could be within the scope of it. Now, the law in Ohio and just about every other jurisdiction is that since zoning restrictions are in derogation of the common law, they have to be read, interpreted, and applied strictly against the township and favorably toward the applicant. So even if there is some arguable, which I don't think there is, but even if there is some arguable notion that we would fall within this moratorium that wasn't even in effect when it got applied to us, even if there's some argument that it's ambiguous and so perhaps we've got the right to read it against you, Ohio law would say no, you don't. You have to read it strictly against the township and favorably, in favor of the applicant. Essentially what we have here is the zoning department is saying, we don't care what Ohio law calls you. We're calling you this. I mean, that would be like saying, PNC or U.S. Bank, I understand that you are a nationally chartered bank, chartered by the FDIC and regulated by the Comptroller of the Currency, but we don't care. We're going to call you a credit union. Or calling Union Savings, which is in fact a savings bank under Ohio law, they say, we don't care what the Ohio Division of Financial Institutions calls you or certifies you as. We're going to call you a credit union. They simply don't have the right to do that. Ohio's Constitution has a supremacy clause, just like the United States Constitution has, and Ohio has defined us as a CSO, a credit services organization. And you don't get to be that unless you do not make loans. Now, I'm not sure what all evidence, Scott is planning or, what Jeff would like. That is the essence of our case. And as I said, I'm happy to make it short because I know that you want to look at all the materials so that you can, frankly, verify that what I'm saying is, is true, that this is what the affidavit said. Greg, the contractor, is here. He's the one that dropped it off, to complete it on July the 18th. A Drummond rep is here. We're happy to answer questions. If you have any questions of me right now, I'd be more than happy, to answer them. Yes, sir.
The protocol we'd like to follow is all the folks in favor of this will allow to speak. Then we'll go to folks opposed, if there are any, and then we'll close that component, and we'll go back and forth with that specific question. So
that's fine. I don't think we have any other presentations other than what I have said and what is in those affidavits. Well, in that respect, let me say one of the things. I did have a nice conversation with Jeff in late August, and I mean that sincerely. It was very gentlemanly. It was very nice. And I asked him, and I guess this is why I'm under oath. I can testify to this. And I asked him, do you actually know, what Drummond does? And then I explained the business model of Drummond, that it does not in fact make loans. And Jeff said, oh, so you're more in the nature of a loan broker. And I said, much more in the nature of a loan broker. And I was thinking that we could work this out, and I said, so the reason I'm calling is because I don't think anywhere in the application that Drummond actually explained itself. Or I don't think they had an opportunity. There isn't a block there to fill out. That Drummond actually explained what all it does, and I said, by the same token, I don't think that you have ever actually looked at us. You just said you're a Kerr title loaner, and so you're in with the rest of these guys, and he allowed us how that was the case, that he really hadn't thought about this issue, and to me that's fair enough, but they were thinking about drafting this in July after the July 18th, submission. They're thinking about drafting it. And I can guarantee you that if they actually knew and understood that Drummond is a broker and does not and cannot by law make loans, that resolution would have been drafted differently. The resolution would have been drafted to take us in under that language. That resolution would have been a lot more precise. Well, sure would. But but that simply points out the nature of what the issue is here. And we simply can't be sucked into moratorium language that Ohio law defines us out of. Thank you very much. I really appreciate it.
Okay, thank you.
And I'm trashing your joint.
Okay. So you're the only representative from Drummond to speak, then I'll go to the opposition. All right, is there anyone who wishes to address the board that is opposed to this application?
My name is Ray McRoberts. I live on Barrowwoods Drive, 3345. And tonight and yesterday evening and today, I went around to the whole subdivision that I live in and basically got an opinion on everybody. And basically, everybody's door that I knocked on, who was home at the time, signed a petition saying that they were not in favor of something like this going on. A short-term lending institution with high interest rates at 86.19. And pretty much, I just kind of voicing my opinion about this. As far as him saying he's not Drummond Financial Services, looking up on the internet last night and just now, we basically found out, according to the Court of Appeals of Ohio, they do specialize in short-term automobile collateralized loans. So, in my mind, I don't know how you can say you don't do that. So, I mean, that's according to the Court of Appeals of Ohio. It's just something we just looked up right now.
You have a case number, sir? Or
I'm sorry?
fill out the case?
I found the same thing. Dated March 13th, 2014. Hakeem Sultana versus Drummond
Should
Financial.
have wrote that down. Sorry.
I just wanted to get it in the
Oh,
record.
case number
Okay.
CV 13808554.
I guess I want to voice an opinion too. As far as these short-term lending institutions, I just did a Google search as far as our neighborhood. 0.2 of a mile, 0.7 of a mile, 3 miles down the road, 4 miles down the road, we got a pawn shop. It just seems like we're saturating our neighborhood with these types of institutions, and it's just something that I'm not in favor of. It just seems like a predatory type of business in my mind. I mean, in 2008, I was one of the people that voted against it. It was a 2-to-1 margin that voted against these institutions for their high interest loans. When they get up to 200, 300, 700%, I mean, some people just get lost in it. It's just kind of a shame. So that's pretty much, I'll give you the signatures from our neighborhood. I have a total of 38. It was pretty much every door I knocked on who was home, so that includes our subdivision. I'm sure there's probably a lot more out there. That's
Sir,
about all I want to say.
would you mind spelling your last name for me, please?
It's MC Roberts, ROBERTS.
Thank you.
Yep.
And if you wish to submit that to the board?
I know there's one more sheet I need. I didn't read back on the sheet, did I?
Is it one of these?
It has a bunch of signatures on it. Yeah.
And then if you don't have it on the
Yeah, I guess another question we wanted to ask is, they're doing work on their property as of now, and without a permit, actually, are we sure we're talking about the right residence? It's not the orange building that's at the top of our street. It's the one that's on the, I think it's on the south side of Skyline.
Correct.
So we were I kind of was under the impression it was a different resident, but it's still pretty close to our neighborhood.
We'll let the record reflect, we've received 3 pages of signatures. The top line reads, residents in Beaverwood subdivision who oppose a short-term lending institution with high interest rates located at 8619 Colerain Avenue. There are three pages of signatures. I will pass this around to the board. Thank you.
The verbiage verbiage is a little different on each page. Yes, or this morning, I should say this afternoon, the last page pretty much emphasizes short-term lending institutions. The first two pages say cash loans, and I was just basically emphasizing a point, but I was explaining to these people, what was going on, so
Okay.
I don't think there's really that much of a difference in my terminology.
Okay.
Thank you.
Anyone else speak in opposition to this proposal? If you need to address this, you have to come up here.
Hi, I'm Angela Duggins.
I'm sorry, your name again, please?
Angela Duggins, Duggins, and I live at 3311 Bowerwoods. What I asked is...
Ms. Duggins, were you sworn in? Did you raise your hand?
No.
Okay, you might want to do that.
I missed that. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in matters before the Board of Zoning Appeals?
I do.
Thank you. Thank you.
My question is do you want us all to speak, or was it okay that he spoke collectively for everybody?
It is your discretion if you wish to, if there's something that you can say that is different or adds more light to the discussion, that you're welcome to do so.
No, we put it together. Thank you.
Thank you. Anyone else? All right, I'll ask for a motion then to close the public input.
I'll make the motion.
I'll second.
Motion's been made and seconded. Roll call vote, please.
Bartle.
Yes.
Yes.
Price.
Yes.
Yes.
Yes. As I mentioned earlier, I have not personally had a chance to review all the material that's been laid in front of me in the last 30 minutes or so.
We also intend to put on some evidence as
Yep,
well.
so I defer to council to,
Go ahead.
go ahead.
I'm just going to remain seated here. Obviously, our position a little different than the applicants. And what I intend to do right now is put on evidence with respect to, first and foremost, why the application was incomplete, and then secondly, address why it is also pursuant to resolution number 5214, the moratorium is applicable, and it is in fact a car title loan
If I
business.
could just interrupt, just for the record, identify yourself.
Scott Solomon, the attorney for Colerain Township.
Thank you.
And a pond business as well, and/or a pond business. I guess initially I'll start with respect to diving further into the process which occurred. Jeff, if you want to kind of start with respect to, first and foremost, I guess you received the application, kind of pick up from there and tell me what you remember.
So we get, year to date, 410 zoning certificates. It's one of the many things we do in a very busy office. Typically what happens, and that's why it's very difficult for me to remember what happened on March 19th, 2014. This came in as a typical permit, just as any other typical permit would come in. So typically what would happen is someone would apply, someone from my staff would take in the application. That person could be Connie Cunningham, that person could be Becky, it could be Julia. At this point, not, of course, in March because Julia wasn't working there, it could be me. It could have been Gina. So someone from my office takes in the application, and then it's placed in a stack, and that stack gets reviewed on Tuesday or Thursday, whichever is next, basically. Sometime, yeah. And then I would review the document, and in this case, it was not in this case, it came in as an interior alteration, and
Do you know who took in the application?
according to the application, the notes on the application, Connie Cottingham's her initials are on the application, so my assumption is that she took that application.
So your first contact with the application was on March 19th, 2014?
The first contact of my office, yes.
Okay. When did you come in to have a chance to review it?
I was thinking I likely reviewed it on March 25th, which would be the following Tuesday.
And what did you notice with respect to the application?
It was an application for an interior alteration. However, on the application itself, it said that the use was changing from a garage to a loan office,
What did that require?
a change of use certificate.
Okay. What did you immediately then do with respect to the file when you realized that?
Typically, what I would do is take a Post-it note like this and write down what it's deficient for.
In this case, because of the need for a change of use, how was the application deficient at that time?
At that time, the application, we received a site plan, but we didn't have a landscape plan or a lighting plan.
So there were three things that needed to be provided to your office then?
For this application.
And those were the site plan, the
Landscaping plan?
landscape plan, and the lighting plan?
Correct.
Okay. Aside from creating a Post-it note that you put on the file, did you do anything else with respect to that application?
Yeah, sure. I would pick up the application and contact the applicant and let them know that it is deficient, and so the application is not complete. In this case, the applicant was Drummond Financial, and there was a 770 area code that was called.
And you referenced 770 area code. Where did you obtain this number from?
The application itself.
What did you proceed to do what type of messages did you leave when you called them?
It would have been, your application materials have been submitted. However, they are deficient in the following ways. There needs to be a landscape plan and lighting plan to complete the application.
Okay. Did you talk to anyone in person, you recall?
I don't recall. I don't recall.
Would this have been notated anywhere in your file?
Yeah, so we use a program called Excella to track our files, and this record number was Z2014-00073, and there was a notation on March 25th, I believe, that said, wait a minute, that said that 32514 permit records indicate, oh, wait a minute. 32514, review found revisions required, change of use certificate plus site plan showing parking, lighting, and landscaping.
And so, based upon that notation, you believe you communicated that to the applicant?
Yes.
Plans are, I'm sorry, the applicant's, counsel for the applicant has talked about, I guess, 5 business days. When does the clock start ticking, so to speak, on an application?
When an application is complete.
Okay. Is it happen quite often that applications aren't complete?
Yes.
And at that point, then you notify the applicant that they're deficient?
Yes, and we put we have a place in our office where incomplete applications live.
Tell me about that process.
So, once we notify an applicant that their application is deficient, then it's basically that's when our responsibility stops, because we have notified them that their application is deficient, and yes.
I was going to say, is there a follow-up method as far as, or is the burden on them to complete the application, so to speak?
That's right. That's an applicant needs to submit an application, and it's not like it's something that we hide what you need for an application. It's in fact published in a zoning resolution that's a public document available on our website, written in plain language. All of the rules for development are there.
So at the time, if the application is incomplete, are you able to approve or deny that application?
There's no complete application to approve or deny.
Okay. And how does one determine what is a complete application?
The Colerain Township zoning resolution.
Aside from your May 25th call, did you have any other contact with this applicant or anyone associated with this applicant?
I had a number of calls with them, and unfortunately, I don't have a piece of paper that shows that I talked to them. But yeah, we've spoken. There were a number of people involved in this case. There's Pontia is the architect. There's H&H, which was the contractor, Drummond, and then there's Atlantic Sign Company, who was the sign vendor. So I and my staff was in contact with them.
And when you were in contact with the architect, the other sign vendor, and other people associated with Drummond as well as Drummond, did you tell them of any, or alert them to any deficiency with respect to the application?
Yeah, anytime somebody would call, what's the status of this, which didn't happen very frequently. And in fact, we were discussing earlier how we would have conversations about how long this application has lived on the incomplete application file.
And when you say we, who are you talking about?
Becky Reno.
Okay. And it's your understanding that she had well, to your knowledge, did Becky have any contact with the applicant?
Yes, I'm certain that she did, and we've discussed her conversation with Tommy Reed, for example, of the Atlantic Sign Company.
And I understand at some point that the applicant did satisfy at least a portion of the deficiencies. Is that correct?
Yes, so in July, the applicant provided a landscaping plan.
And so that was communicated, and you obtained that. Did you ever receive a lighting plan?
To this day, I have not received a lighting plan.
Okay. And so today, the application still is incomplete?
Correct.
Had you received a lighting plan today, would you be able to approve the zoning certificate with respect to the change in use for the property located at 8619 Colerain Avenue?
No,
And why is that?
because on August 12th, 2014, the trustees passed a resolution that placed a moratorium on alternative financial service providers and named car title loan businesses, and also named pawn businesses as alternative financial service providers, and directed me not to issue zoning certificates for these uses for a period of 1 year. And
Did you, well, tell me, I guess, is that, that's otherwise known as Resolution 5214, is that correct?
correct,
And did you have any role in drafting that document?
I did.
Okay. At issue with respect to this hearing is the definitions of car title loan business. There's been reference made to the fact that applicant maintains that they are not a lender. Well, and for the record, I'll go ahead and bring the board's attention to one of the documents I provided at the prior, a public record. I did a search on the Ohio Secretary of State, and you will see that Drummond Financial Services, the applicant, his registered trade name is Loan Max. Does Loan Max ring a bell with you, Mr. Mills?
It does.
And what was your understanding of that Loan Max?
Well, we have a Loan Max that is owned by Drummond Financial and was built or rehabbed by H&H Contractors, currently on Galbraith Road.
So with respect to the application, was it your understanding that Drummond Financial Services would be operating a Loan Max at this with respect to the change of use request?
If past was Prelude, I would, yeah, it's the name they do business by.
And you talk about other interaction with, I guess, Drummond Financial Services, correct?
Yes.
Tell me about that.
Well, last year, Drummond Financial Services applied for and received a zoning certificate and is currently in operation on Galbraith Road. And that's one of the interesting things about this is that, there's this claim that we didn't know what it took to get a zoning certificate, when just 9-12 months earlier, they were able to successfully provide me with every document that I needed. And that's an important point, because it was the same contractor and the same applicant owner. The only difference was there was an architect, there was a different architect. So the claim of, oh geez, I never knew what it took to get a zoning certificate is troubling to me.
And with respect to the Galbraith property, did they provide a lighting plan with respect to that application?
Yes, they had to, because it's required by the zoning resolution.
Okay. And in the resolution, can you point to anywhere in the resolution which would put the applicant on notice that a lighting plan is required with respect to a change of use application as well?
Yeah, so lighting plans, our zoning resolution references the standards for outdoor lighting on section 12.9, and section 12.9.2 says very clearly that the regulations of this section shall apply to all lighting that illuminates the exterior of a building, structure, open space, parking lot, loading area, or other feature of a lot. Lighting plans shall be submitted for approval with all applications for zoning certificates in the R6, R7, B1, B2, B3, etc., other zoning districts. There's no way for me to issue a zoning certificate without a lighting plan per our zoning resolution.
Is there any other portion of the resolution that you believe would put them on notice with respect to needing a lighting plan?
Well, let's see, Article 4. Article 4.2.3 outlines our review procedure, and the first step in our review procedure for a zoning certificate is, the applicant shall submit 2 copies of the following to the Township Zoning Administrator prior to submitting for a Hamilton County building permit. The second item there is all such forms, maps, information as may be prescribed for that purpose by the Colerain Township Zoning Department to assure the fullest practicable presentation of the facts for the permanent record. Basically, it says, we've written everything that you need to do down in this book, and that's what that it's very clear.
And you also provided your instruction on March 25th, correct?
Yes.
Did you determine what Drummond Financial Services was going to do with respect to how did you know what they were going to change their use for?
On the zoning certificate application, there's a question number 7 that says, basically identify existing and proposed uses of buildings and premises. On that application, they listed the existing use as a garage and the proposed use as a loan office.
Okay. Did you have any other, ways of finding out what you believed, or aside from the fact that they listed themselves that they were going to be a loan office, did you do any further investigation with respect to loan max at all?
Well, I did initially when I was looking through the zoning certificate, working through the zoning certificate process for the loan max on Galbraith Road. You can see what they do there, by just going in there, and you can also look at their website, which is very clear what they do.
And I've printed off, portions of the website. I want you to kind of take a look through 2 documents. One, and I provided this to the board as well, about loan max title loans, and the other document, the collection of documents, is frequently asked questions. Are you familiar with?
Yeah, I've seen that on their website. It's on their website.
Can you go through these documents and pick out portions of what made you believe that?
It's very difficult to understand the argument that, Drummond Financial does not make loans, because when you look at the material that they provide on the web, it gives a very different impression than the impression that their counsel has given tonight. So, for example, on their website, it says under the about Loan Max title loans, it says Loan Max is one of America's most respected title loan companies. It goes on to say our company's mission is to provide short-term loans to our customers using a process that is hassle-free. Their slogan is cash loans on car titles. On the Contact Us page, it says, if you would prefer to discuss our loan process, leads me to believe that they are involved in making a loan. If you look at how does a title loan work, they say you just bring in your vehicle, the title to your vehicle, into Loan Max. While it says step 2 is while you complete a very simple application, we will do a quick evaluation of your vehicle. It tends to indicate that they are in the process of making a loan here. They talk about the repayment obligations of the loan. And then step 4 is within 20 minutes of your arrival. Within 20 minutes of your arrival, you'll be leaving with your vehicle and the cash you need. It's just hard for me to understand, just using common sense, how an organization can take in a loan application, inspect a vehicle, provide cash within 20 minutes, and not be a part of making a loan. It doesn't stand. It just, as to my way of thinking, it doesn't make sense. When on the website where they talk about the benefits of a title loan with Loan Max, They say, instant cash in your pocket, instant on-site approval, same-day loans in 20 minutes or less, no lengthy application period. It's hard for me to understand how they're not involved in making a loan. Borrowing from LoanMax, it says, gives you top dollar for your car and the instant you need the money.
And is that on page 5 of?
That's on page 5 of the packet. On page 6 of the packet, it talks about benefits of a title loan with LoanMax. LoanMax doesn't even look at your credit score. It doesn't look at your credit score to determine whether you're approved. Your vehicle is your credit. Many lenders require many lenders require several proofs of income, proof of employment, numerous utility bills, proofs of insurance, and even tax returns on business license. At LoanMax, many lenders, and then they say, at LoanMax, we require your title. It sort of infers that they are a lender. Many lenders require this, TitleMax or LoanMax. No. Our loans on page 8, our loans typically require that payments be made monthly. That's their loans. It doesn't say somebody else's loans, it says their loans. Gives me the impression they're making a loan. You can pay off your loan at any time. We do not charge a prepayment penalty ever. Page 9, because we do not report to credit agencies, no one will ever have to know that you needed our help. No one will ever have to know that you needed our help. If there was a third party involved, how would they know that it doesn't make any sense? This is just, it doesn't pass the sniff test, if you ask me. When you look at the frequently asked question, I can go on with this.
I know, and if you've picked up the other document, frequently asked questions, we can.
It's a document that you all can see. It goes on and on and on to give the impression that they are making loans. And to be perfectly honest with you, when I worked on drafting this, okay.
And that's what I was going to get to. So is your belief that they were a lender, despite what they say?
It didn't matter to me if they were a lender. It mattered to me if they made loans.
Well, what is a title loan? To the best of your knowledge, did you find out what that was at all? Or?
Yeah, well, on their website, they say a title loan, also referred to in some places as title pawn or motor vehicle equity line of credit, is a short-term loan that uses the free and clear title to your vehicle as your credit. At LoanMax, we don't do any credit checks. Your vehicle is your credit, which also opens the door to, maybe it's not just a car title business, it's a pawn business also, because they're making short-term loans collateralized by tangible property.
And you drew the conclusion then that at least in some way they were either the car title loan business and or a pawn business. Is that fair to say?
Yeah, based on the definition that we used in our moratorium, yes.
And let's talk about the definitions of the moratorium. There's been talk about, is there anything that you could tell me with respect, you had a hand in drafting this. Is the word lender included in the definition of a car title loan business at all?
It's not, because it's not, the purpose is those who are making these loans. And as I look at, all of the businesses in Colerain Township that are making car title loans, LoanMax is one of them.
Looking specifically at the language, is the word loan, it says establishment. What is your definition of establishment?
The definition of establishment that's on, that is online on Merriam-Webster is, I printed it out, of course, and I can't find it. But you are an establishment. Fantastic. Okay, so then the operative word then, I believe, from the materials that I've received from Drummond is made. Do they make loans, right? It doesn't say, do they lend money? Are they the lenders of the money? It says, are you making the loans? And if you are taking in an application, if you are checking out the tangible personal property that will collateralize the loan, if you are handing the money to the person, if you're collecting the fees from the person, that to me is making the loan. And that's how I interpreted that language. That's how I wrote that language.
And so with respect to, you still believe, is it correct that you still believe they were a lender?
I don't think that it matters personally, but they are making a loan, yes.
Okay. So, and I guess that's what I was trying to get at, is the fact that even if they weren't a lender, the moratorium would still be applicable, correct?
Yes, correct, yes.
But in your opinion, do you believe they are a lender based on the information you provide us as as to your research online and
I mean, it looks like a duck, it sounds like a duck. I'm calling it a duck. Yes, it's a lender.
Becky. I'd also like to call Becky Reno with respect to any information that she knows. Becky, did you have any contact with the applicant in this case?
There were several phone calls. I'm not really sure who it was from. And, you know, there was asked, what's the holdup? And we say, well, we're still waiting for the landscape plan, the lighting plan. I specifically remember speaking to their sign contractor, Tommy, and, you know, he wanted to know what the holdup was. And I told him specifically, well, change of, and we required a landscape plan, lighting
Excuse me,
plan.
Mr. Summer, it was, Becky, were you sworn in?
Yes, I was.
She was.
Thank you, okay.
So, yes, I did talk to their,
And
contractor.
do you know specifically you talked to the applicant, or did you just talk to people affiliated with the applicant to the best of your
I
knowledge?
know people affiliated with it.
But, do you have a time frame with respect to these calls?
I know that sign contractor, I talked to him in May.
And how do you know that?
I had listed it. I had entered it into the computer when I spoke to him.
So that's notated on the computer?
Yes. And we, you know, we want to issue permits. We don't like them piling up, so, you know,
Did you, Mr. Mills referenced a conversation about this particular application, and it's sitting in the, I don't know, on the table, for lack of a better word, but you remember that kind of, or type of conversation at all?
we had a couple of conversations like that. One of us, someone would take a phone call, what's the holdup, and we would tell them we're still waiting for the landscape plan or the lighting plan, and then, you know, we would say, gosh, you know, still waiting for the plan, wonder what they're waiting for.
What typically happens when you notify someone that the application is not complete?
Within a matter of days, most people want their zoning certificate, so they immediately bring us whatever's needed.
Okay. Do they ever come in personally?
Oh, yes, usually they do, yeah.
And do you remember that happening at all with respect to this
I
case?
do remember a landscape plan being brought in.
But to your recollection, there was never any lighting plan, correct?
No.
You know, one thing that I did want to talk just a little bit about, is that hot? No, sorry. I don't know what that noise is the, what is it?
Turn it on and off again.
Here, I'm gonna switch this over here. And the microphone had to be on for that. All right, I apologize. One thing I wanted to talk about was the moratorium and sort of the legislative history of the moratorium. You know, since I've started here in Colerain Township, we've had a number of, and anybody that lives in the community knows, there have been a number of the types of uses that are included in the alternative financial service provider definition. A lot. And it has come to my attention just by my personal observation, but also by attending seminars with the American Planning Association, that these, and personal research, that these types of uses, which had been regulated as just financial services providers, have a different impact on the community. And I think that anybody will tell you, they have a different impact. LoanMax has a different impact on the community than PNC Bank does. And so it's my opinion that they need to be, need to be regulated differently. And so what the purpose of this moratorium is just to say, hey, time out, everybody, time out. There's been an influx of this use into a very small portion of our township. Give us the opportunity to review the literature and what other folks are doing as it relates to the regulation of this use. And so we're not saying they can never come back. We're saying for a period of 1 year, we're going to look at our resolution because there's been a huge influx of these. And that process has been going on for a very long time. I mean, you know, moratoriums just don't appear out of nowhere. It takes a very long time, a lot of research. The American Planning Association conference that I was at was in April. You know, there's this specter that's being presented, it seems, of, you know, some sort of like, hey, we got to hurry up and sneak this in. We didn't make it an emergency resolution. It wasn't made an emergency resolution. On August 20th, the applicant could have submitted a lighting plan. They didn't. I mean, this isn't focused on this application or on this applicant. This is a reaction, a legislative reaction to a broad issue in our community. We're trying to become a best-in-class community, and we're well on our way to that. And these types of uses simply don't help us move in that direction. And so we're saying, time out, let's review our regulations and make a presentation to the Zoning Commission.
With respect to, and I just want to kind of follow up with a few questions. Do you know what type of, you know, loans that Loan Max would service? Like the amount of loans?
Their website, I believe, said $100 to $10,000.
And do you know where any of these payments were made? Or did the website indicate where payments could be made at?
I believe the website said you could actually make the payments at the Loan Max office.
How long does the website say that the loan would be completed from when the applicant would walk in, your recollection?
I remember it being 20 minutes.
Is there
No, there's not.
well, aside from the fact that looking at through the exhibits, frequently asked questions, and about Loan Max title loans, this is all information you reviewed from the website, correct?
Yes.
Thank you. In our normal protocol, the board, I'll open it to board questions. Again, we haven't had a great deal of time to look at the material, but there's also an opportunity for cross-examination at this point. So at the board's discretion, do you want to defer to the opposition, let them ask questions, or do you want to go into the questions yourself?
I think we should allow the applicant to do the cross-examination
Okay.
before we ask questions.
Right.
I agree.
Jeff, when did you start looking at the Loan Max website?
The first time I had come across Loan Max was when they applied in 2013 for the Galbraith Road project.
But is that when you were looking at it? Because the printed off material is October 22nd or something.
I've looked at it today, and I've looked at it a number of times.
Did you look at it before you denied the application?
Yeah.
Is that why you denied the application?
No, see, there's a bit of a discrepancy where I denied an application. There wasn't a complete application to deny.
Let me say this. Moving past whether the application was complete or not, on August 20th, you advised Drummond that you were not going to approve and couldn't even take in an application from Drummond for a Loan Max because the moratorium was in effect, right?
No, let's be real clear about this, because I think it's a little bit
let's get
fuzzy
real
here.
clear.
Yeah. Although numerous attempts have been made by our department to your representative requesting additional information required to issue the permit, the application remains incomplete. Therefore, with the passing of the moratorium, we are unable to issue a zoning certificate for the reference property. On August 20th, there was not a complete application, and, point of fact, the trustees had passed a moratorium.
But the moratorium was not in effect.
Correct.
It was not in effect.
Correct.
And you told them with the passage of the moratorium, we're not going to rule on your application.
If you would have provided me a lighting plan on August 20th, I would have taken it in, and I would have called Larry Barbier. And I would have asked Larry Barbier, Larry, where are we at? And likely, he would have told me the truth, which is the moratorium's not in effect. There would have been a zoning certificate issued.
So you didn't know that the moratorium's not in effect?
I would have checked with Larry, because it's my practice when there's a situation such as this. How often have we passed? This is the first time we've passed a moratorium.
Let me back up. And I don't mean to suggest that you intended to misrepresent anything, okay? I'm not saying that you lied to anybody, okay? All right? What I'm saying, though, is that on August 20th, when you say the passage of the moratorium, we're not going to do anything with your application, and won't be able to do anything for a year, right? That's what you say in the letter.
I don't think I say that in the letter. I don't say that in the letter.
That, aren't you telling Drummond that it's in effect?
I said, therefore, with the passing of the moratorium, we are unable to issue the zoning certificate. There's no, you didn't have a complete application, and there's a moratorium passed on August 12th.
Now, are you aware that Drummond is nationwide, right?
Yeah.
Loan Max is nationwide,
Right.
nationwide. And in some states, they actually do make loans. So, I mean, all of your business on the website, that applies in about 45 of the 50 states. It doesn't apply in Ohio. Do you know that? I mean, did you bother to go past what the website says and actually ask Drummond what in fact they do?
It's interesting because I was sitting in Ohio looking at this information, and that was the information that was given in Ohio.
Not exactly, because one of the pages, and you put it in, we've also put it in, but on the bottom of the web page, it says, in Ohio, Loan Max is not a lender.
And again, I think I said this earlier, it doesn't matter if you're a lender or not, you make loans.
I see. And you define making loans in some fashion different than Ohio law defines making loans?
So when I wrote the words making loans, the things that come to mind as I was writing that would have been, do you take in an application? Do you observe the tangible personal property that is going to be collateralizing the loan? Do you, you're doing all the things that loan makers do. So I would call you a loan maker, yes.
Would you say a mortgage broker is a loan maker?
They are part of the loan-making process.
So they make loans?
They are part of the loan-making process, sure.
So they make loans, yes or no?
I'm not
Define
familiar.
them as
I mean,
making
to be
loans.
honest with you, it's not germane to this, and I don't know I don't know.
But essentially, though, if this board decides that the moratorium doesn't apply to Drummond, you'd have no problem with taking Drummond's application for a Loan Max and getting the lighting plan and teeing it up.
Say it one more time.
If this board decides that the moratorium does not,
Apply.
did not on August 20th, does not now, will not till September 12th.
Apply to your business.
Apply to Drummond.
Yeah.
You got no problem with completing the application.
Yeah, I mean, that could have happened at any point in time.
Fair enough?
And it, in fact, happened last year on Galbraith Road. Yeah.
Okay, thank you. We'll go to the board for questions. We'll start with Mr. Roberto.
This is a sticky wicket. And so help me understand your process, if you could address with either yourself. I want to know, if I come into you with an application, what the process is in the state of Ohio. And so if someone can give me that representation, whether it's legal or yourself, I would like to know. You need to go to the podium and address yourself, please. And you'll need to be sworn in.
I was.
Who was that?
I was. My name is Steve Mark. I am the Director of Construction for Drummond Financial Services. In Ohio, someone would come in with their vehicle, with their clear title, and an application is filled out for integrity funding. The integrity has given us a list of qualifications, requirements, year, make, model, black book value. I may be leaving one or two steps of that out. But in essence, they have asked us to assess the car, take in the application, then that application is put into the computer system. It is reviewed by Integrity Funding of Ohio, and the application is either then approved or denied based on the information that is given to us by the prospective customer, and the funds are issued.
And so, in this instance, I come to your establishment, I have a vehicle that's worth, whatever, $20,000.
Sure.
I want a loan for $10,000. You go through the process, and then you write me a check, or how does that happen?
A check is printed on Integrity Funding's account.
Okay. All right. Are you currently under contract with the facility that you're wanting to renovate?
We are.
Okay. And that's all the questions I have at this present time. I may ask for some more later, please.
Mr. Martin?
Well, I agree with Mr. Roberto. This is a sticky wicket. And as interesting as some of the constitutional issues are, conflicts of law issues, and really the public policy and really the effectiveness of the moratorium. I think all of those things are beyond the scope and the jurisdiction of this board. So, I mean, even the advisability, I mean, I could make the same argument about no more fast food restaurants for a year in Colerain, that there was much harm, perhaps, as these guys. So I don't think that's, on both sides, I don't think that's a relevant argument. So I'm going to stick to the arguments that I think are within the jurisdiction of this board. And I am troubled because I do think the wording, I agree with counsel, we have very limited ability, and been pointed out numerous times by counsel to me and others on the board here, we do have to strictly interpret the language. It bothers me that in paragraph 3, the definition, the use of the word "or facilitates." If we would have put the word "or facilitates" into number 1, we probably wouldn't be here. Because number 1 says makes, number 3 under money transfer business says "or facilitates." So I think that's an issue with the drafting. The other question, why use of the word small? $10,000 is not small. I mean, I wouldn't have put the word small in there either. I think you didn't make that argument, but I think there's an argument to be made that that your loans are not small loans. They're not $500 loans. They're not $1,000 loans. They're up to $10,000. So, again, I'm not saying that I like your business. I'm not saying that we need more of your business. And again, I really don't want to get into the public policy issues because I don't think that's where we belong. So I'm stuck looking at the wording of the ordinance, and truthfully, I'm having difficulty seeing why you don't, or why you're not outside of the language of the moratorium. And then that leads me to the communications issues. It does trouble me a little bit. There was nothing in writing from the March 25th on to the applicant. Everything is just noted in the...
That's not true. There was an email between myself and Pontia Architecture related to the landscaping plan. There's also, I believe, an email correspondence between myself and H&H.
But saying that you were denying it or not? Or just saying that
no,
it
was actually in response to phone conversations that we had where they had asked questions, and then we're looking for more detailed information about, for example, what constitutes a landscaping plan. And so I would email them the zoning resolution and say, pursuant to our conversation, look
So between March 25th and July, there were emails going back and forth?
There were at least 2 emails going back and forth and numerous phone conversations. Unfortunately, I don't have a record of that.
Okay. The issue in, I guess, the whole issue of the language, did council review it? Did you guys review it?
Yeah, I sent it to Larry Barbier.
And he approved it?
He approved it as to form, yeah.
No. Again, there's all sorts of model language that's available, and I don't know why that language was used, the makes language, and where used "or facilitates" later on. And again, I know it's going to be interpreted as me casting aspersions, then that's not what I'm doing. I'm trying to live up to my role as the board member here, and I'm trying to focus on what I think is the very limited role that we have here, public policy aside. And we can agree or disagree on the public policy issues. It's just a question of whether, in good conscience, I can say this language applies to this particular applicant. It does trouble me a little bit, the conversation on August 25th, whether because the language of the letter, in all fairness to the applicant, does say, if I can get to that letter here, it says, therefore, with the passing of the moratorium, we are unable to issue the zoning certificate for the reference property. Now, I think we've all agreed that on August 20th, that's not true. Correct?
What?
I believe it was Jeff's understanding, though. I think it actually is the understanding of the trustees. I think that was put in place, too. If you look at the wording of the resolution.
Yeah, but here's the deal. Even if the language issue, even if I make the language issue go away, and we take makes and expands it to mean "or facilitates," on August 20th, the moratorium wasn't in effect.
And even assuming that there was,
right?
The other argument would have been there's no complete application yet. So
right, but on August 20th, they get a letter saying you might as well quit now because the moratorium's in effect and I'm not issuing a zoning certificate. I mean,
It
that's what it
specifies
says.
that it's incomplete.
Therefore, with the passing of the moratorium, it doesn't say, and the incompleteness of the application.
Oh,
I mean, again, there's a dearth of, in my opinion, a dearth of written correspondence between your office and the applicant relative to this whole process.
could I touch on that for a second?
Well,
Okay.
sure. Well, let me just, finish my point. So, with the dearth of written letters or correspondence, there is one letter that's here on August 20th. And that letter, I mean, you know, you want us to use the common parlance with the word makes. Well, I'm using the common parlance with the sentence that says here, therefore, with the passing of the moratorium, we are unable to issue the zoning certificate. It doesn't say, and also because you have an incomplete application. Because on August 20th, actually until, September 12th, they could have gone back and submitted the information.
September 12th.
Correct?
September 12th, maybe.
September 12th, I said, yes. Until September 12th, they could have submitted, and even if the moratorium applied to them, they would still be entitled to the certificate, correct?
Yeah, and this is for a zoning certificate that usually takes days to process.
Right.
And this is with a company that has hundreds of locations across the country and does this for a living to make money. This took 6-7 months. I don't know. I don't know if we can focus on like this period of time down in August, and we should, but it's just interesting to me that that's really the crux of it.
I agree, but I think in good conscience and in good faith, you can make, I hear what they're saying and I hear what you're saying.
Sure.
But I think on August 20th, which is, 23 days before the moratorium comes into effect, even if it applies to them, they could have in that 23 days submitted whatever they needed to submit to get the zoning certificate.
And with talented counsel as they have, they probably should have been advised that, in fact, that moratorium was not in effect, and they could have provided me a lighting plan, and I would have gladly issued a zoning certificate.
But there's also, we also have a talented zoning administrator who wrote them a letter saying you wouldn't issue it to them.
They didn't have a complete application.
I
I couldn't issue it because they didn't have a complete application on August 20th.
Well, I'm not going to.
I know what you mean.
I'm not going to beat the horse. You know what I'm saying.
I hear you. Yep.
All right. All right. Well, I think that pretty much, let me just make sure I got all my questions in here. Because it is a very difficult issue. I mean, again, I don't want anybody to perceive me as a proponent of potentially bad lending, and I don't suggest that they engage in predatory lending. I'll leave that up to other people to decide. So I'm not an advocate of this business, but at the same time, you have to treat them fairly. And I think in fairness, you have to read everything that's here to allow them to do what they want to do. So I'll leave it at that. And I will, as Mr. Roberto did, I will reserve some time later on after I review the documents to maybe have another couple of questions.
Okay, Mr. Price?
On the paperwork that you submitted off the government's website, off the State of Ohio's website, according to Drummond's application for their business, it lists them as a loan broker. Can you explain to me what the word broker means in this term?
I'd say it takes on the definition probably you would find in Webster.
Okay. But
The regular definition, broker.
I mean, in my eyes, a broker would be somebody that facilitates a loan but doesn't necessarily give the money.
That's a fair interpretation, I'd say.
So therefore, it's like, me going into, Kia looking for a new car. They don't give me the money. They go out and get me the loan so I can get the car and drive off the lot that day.
Well, I think if we look at the case, if the court has already held that they are a lender, I think that's a moot point almost, because they've determined that they are a lender. And I haven't seen the case, but if that is in fact the case, they've been held to be a lender.
Well,
I don't know. I mean, I haven't.
I'll take it as argument.
they, just quickly, I mean, it was a case of one individual suing Drummond. And then it's under point 1, factual and procedural history. They just say Drummond operates lending businesses that specialize in short-term automobile collateralized loans. And then it says on July 27, 2012, the plaintiff secured an automobile title loan with Drummond. So that's, court record.
And pursuant to their definition of a title loan, it's a title loan, also referred in some places as a title upon, or a motor vehicle equity line of credit, is a short-term loan that uses the free and clear title to your vehicle as your credit. They don't do credit checks. I mean, the vehicle is a credit. That's exactly, what else is a car title loan business?
Right.
I
mean,
guess.
I fully agree with you.
And
I
the
mean-
fact that they receive the payments, it's not like they broker the deal and they never see again, where are you making the payments to?
Yeah, and I understand too. I'm also, I have some issues with the language of the resolution as well. So, and I don't think it's as clear as everybody thinks it might be, whether it's for or against. So, but that's really the only question I had.
And if I may just say one thing, in instances where there is, requires an interpretation, oftentimes I interpret these things. And then if my interpretation is different from what, for instance, in this case, Drummond's interpretation, then they take it to you guys, and then you guys interpret, right? Mm-hmm. That's the whole game right here, so.
My only comment would be, I also agree with Mr. Martin's language. Should be modified, but if it can at this point, stays the way it is. But on the other hand, a car title loan business is something where a person enters a building and comes out with a loan. So Drummond is making a profit off of this transaction. But they truly do, for the state of Ohio, have that designation as a CSO. That's their way around it. So we could spend hours debating that, which I would agree is not necessarily ours to do so.
All right.
But getting back to your procedure, so on March 25th, you don't, when there's a deficiency, you never send a letter out, correct?
We do not.
And then you make a phone call to the phone number, and if nobody's there, you just leave a message.
Yeah. And oftentimes what happens is people come to get zoning certificates because they want to build something, and
Right.
they want to build something. They're gonna call me the next day and say, hey, where the heck? There are many instances where people are like 2 days later, they're like, where's my zoning certificate? And I say, oh, it was missing this, and spin it around in a heartbeat because they want to build something. And it doesn't take 6 months usually.
But there is proof that they were deficient in a lighting plan.
On March 25th, they were deficient in landscaping and lighting plan.
Yeah.
Yeah.
Yeah, that's all for.
Okay. We're at point for final questions and concerns. Any board member or representatives?
Well, I guess I did have a question. I mean, the proximity of probably for you. How did you come to pick this location when you have one literally less than a half a mile away?
The honest answer in that was we have several departments within our organization. I do the construction side and not the real estate side. I wish I could give you an answer of exactly why. I would be purely taking a guess.
So there's not a demographic plan that you look to target an area?
I'm sure there is. I mean, I'm sure there is. I'm sure there's always a demographic of population density, as in any business probably looks at going into any particular market. I just honestly can't answer your question in that one because I don't do that for the company.
Well, Colerain Township is notorious for having two of everything. So, I mean,
Okay. I'm guessing, sometimes it's probably based on, here's what I can give you. A lot of times it's based on traffic patterns. Sometimes you'll go up and down a busy road and you'll see a speedway on this side and a speedway on this side because typically people going this particular direction can't get that side for any particular location. These people can't get that side. So I'm sure there was obviously thought put into it. Well, I'm 100% sure there was thought put into it. But I would give you that analogy.
Well, in our particular area, they tend to be a little further apart than where you are currently wanting to put this facility.
Could be.
So I'm just trying to understand the logic of how you came about. It's really not even germane to my own curiosity.
Sure.
That's all I had. Thank you.
Any other questions?
And I just wanted to ask a question just to have a chance to cross real quickly as far as, were you involved with the Galbraith location?
Yes, sir.
H&H?
Hmm?
And in that, were you aware that a lighting plan was submitted with respect to that application?
I don't believe that the Galbraith location has an exterior lighting plan with that submission, nor was one asked. the landscaping plan, certainly. I wouldn't swear with 100%, but I would say probably 95% certainty that I didn't do any exterior lighting on Galbraith Avenue.
But you were involved with the project that was approved.
Absolutely.
I had a question also.
Another question? Sure.
I'm just curious why a lighting plan for this property wasn't. Even, he said it was asked of you to, to provide one on March 25th.
But my answer to that is, the correspondence that I got, let me back up. My number is on that application. I received 0 phone calls on this project, ever. Not one. My 770 number is my cell phone. I travel, I answer that as many times as I possibly can. I never got a single phone call. I knew that it was missing the site plan, parking plan, landscaping plan. The reason we've speculated it takes so long, I went out and had a new survey done of the property, which took about 30 days for that to turn around. Then we sent it back to the architect to do the landscaping plan, who did then have correspondence and was given just the landscaping section of the zoning ordinance to follow. Honestly, the letter that we got when I sent my, the one gentleman who works for me, Mr. Edwin Evans, was the first time I ever heard about lighting plan.
So how did you know you needed a site plan and a landscaping plan?
That was in correspondence in the email that was received by Dave Ponte, our architect. But it did not reference lighting. And then the lighting section wasn't, the landscaping section was sent specifically that here's what you need to comply.
If there was a lighting plan that was provided on the Galbraith site and there was not a lighting plan that was submitted with respect to this site, would you agree that the application was deficient with respect to this site?
Sure.
Thank you.
I just had a couple.
Or anyone in particular?
No, just, well, I guess I really want to speak a little bit to the public here, because I want to make sure they understand. We do listen to what you're saying, but we have a very limited role here. I mean, with all due respect to Mr. Roberto, he and I agree a lot. I don't think it's appropriate to ask them why they want to locate here. We don't ask that of KFC. We don't ask that of McDonald's. We don't, in fact, we bend over backwards sometimes against my better judgment to give them variances. And we don't say, what about the demographics? Have you identified this area as more prone to fast food or not? Colerain is known for doing this. And so, yeah, we may all agree that there are too many of these establishments, but, our role is really to look at the language that we're given, and we have to act on that language. The place to go to change that language or to express your views about different types of business, whether it's this type of business or whether it's a fast food or the size of sodas, as a certain mayor did in New York, is the trustees. It's not here, unfortunately. So we are very, very limited in our role.
And interestingly, they took that policy challenge and instituted a moratorium on these uses.
Policy challenge from whom?
That you're talking about. You're saying it's not your job, it's the job of the trustees. Right. I'm saying they did their job.
Well, I'm saying they did their job incorrectly because, and I think other people on the panel agree, they did it inadequately. And I'll probably, they appoint me, so maybe they'll unappoint me, but the language doesn't support what they wanted to do. That's what I'm saying.
Got it.
Not that they did anything wrong, they just did not do it completely.
Got it.
And number two, I find the footnote on page 1 of the material that you guys submitted, namely the town, to be pretty persuasive, where it says in Ohio, and the folks out there didn't see this, but in the Loan Max material that was taken offline, it says right at the bottom, in Ohio, Loan Max is not a lender. Loan Max is licensed as a credit services organization. We all know in different states have different laws, and for whatever reason, they decided in Ohio not to be a lender. So just because they're a lender someplace else doesn't mean that they're a lender here. And again, that language comes into play. And the only suggestion I would make to avoid these problems in the future is I personally think we should confirm in writing more of the communications as opposed to just telephonic messages. No, I don't think anybody's suggesting you didn't call. I don't think anybody's suggesting you didn't receive the call. But we're left to guess, okay, what happened? I mean, I've got lots of, there are calls that I was told were made to me that I've never received, and vice versa. So I'm not going to take either side on that issue, but that's what we're left with. And the only thing that then we're left with is that letter on August 25th. And I'm not going to repeat myself about that letter, but where there is such a lack of written communication, we're left with that. So my suggestion in the future would be to put more of this, whether it's a form letter, a form email, or whatever, so that we can rely upon it. It's going to make our job easier and yours as well. That's all I have.
Thank you. Mr. Price? All right, we're at a point that we will have to have a motion to either lay this on the table or to approve the request or deny it. So I will ask for a motion to move forward.
I'll move that we determine that the moratorium is not in effect and that pending completion of their zoning application that they be allowed to proceed.
I second the motion.
Okay. Motion has been made and seconded. Any other discussion? An affirmative vote on the motion indicates that they will be given a zoning or a certificate to proceed.
Once they complete with the...
Once they complete the requirement, regardless of moratorium. Is that correctly stated? An affirmative vote?
Your motion, not mine.
Yeah, that's...
Okay,
yeah, that's,
all right.
yes.
Are we clear? The board clear? So
yes.
affirmative vote or a negative vote? Okay.
So just a point of clarity, so if they were to get they submit their lighting application today, right now, their application would be complete.
Let's think about the words here.
Well, let me ask you, what do they need to have a complete application? The lighting? That's all that's left, right?
Yes, hang on just a second. Yeah, could we make sure that the language says something to the effect of, because of unique circumstances, in this case, where a letter was given by a zoning administrator to the applicant, which was considered a denial ultimately, for that purpose, you are, in this case, making the approving the appeal.
Because of the legal definition of their company.
No, because it wouldn't have been in effect on August, and you're saying that because I led them astray,
Right.
a multinational organization that has a lot, because I led them astray, that is the reason why you're approving this variance.
Correct.
I will agree. Yeah,
Yes, sir.
please.
Yeah.
That, that they caused by not drafting a resolution that covers Drummond. I can't help them with it. I don't think you can help them with it. But the motion stated by Mr. Martin and seconded by this gentleman.
And ultimately, it's your motion, so do with it as you will. Right.
What's your objection to that?
Well, look, what they're trying to, they don't want us coming back next week on a new location. So what they want to say is, basically, it's an estoppel argument. Basically, it's, oh, well, because we kind of screwed up on this one, then we're going to let you have your zoning certificate, but we better not see you in January. And the motion Mr. Martin proposed is simply that the language of the resolution doesn't apply to us. And, it's like, and he has stated eloquently, much better than I can. I mean, it doesn't apply to us. We can't help you. We're not the trustees. We can't fix the moratorium. And what they're trying to do is restrict it to this location, this time, this site, this application. And I have no clue where Drummond went. I mean, I can't sit there and, you know, resolve this, and they may not be here for a year. I mean, certainly they're not welcome. They may not be here for a year, but that was, Mr. Martin's motion was seconded, and I think that's the one that gets the vote.
Yeah, but to be clear, I'm not saying that the motion or the resolution as written does not apply to you. I'm saying it doesn't apply to you because it wasn't in effect at the time.
And that's what
It
I
may,
thought Mr.
it may
Martin
apply
said.
to you in
That's what you
future.
said.
I'm not the guy to say that. So, just to be clear
I
on that
didn't,
part.
I didn't specify that.
Well, I mean, and this is part of our discussion process, so that's where we're at.
Well, here's my concern. I do believe the ordinance needs to be redrafted. And I don't think I'm alone in that regard. I mean, I think the language, there is model language out there. I don't know if you drafted this out of whole cloth or not, but there is some model language out there that I would encourage you to look at through various associations that you could probably get pretty easily on the internet. So in any event, I do think it's flawed for two reasons. Number one, it doesn't say or facilitates, and that's a quick amendment that I think they could make. Number two, it says small loans. I think some of these car title loans, I've seen advertisements for up to 50,000, no, 25,000, I think. Some of the loans I've seen up and down Colerain Avenue now advertised up to 25,000. So I would recommend that you go back to the trustees and amend the language to take that out, which would then, I think, answer in some ways the issue that's being raised here, because then they would clearly fall under it if you added the word or facilitates, in my opinion. And again, you shouldn't take my opinion, you should get council's opinion on that. So I don't think I want to specify the language that you want to add, Jeff. I think I want to give you an incentive to go back to the trustees and say, we need to fix this, because I think it's a quick and easy fix, and I think that's what should happen.
On what motion is actually
Right.
at issue.
I will
Please reissue the motion.
Yeah, I move that pending the completeness of their application, which as I understand means that they submit a lighting plan, that everything else is complete and,
At that point in time, it'll be reviewed.
okay. Because what I do want, I want to avoid a situation where they are arguing that it's reviewed too stringently, but I want it reviewed appropriately. Obviously, you'll do that.
It's in black and white
Okay.
letters.
So pending their completeness of the application and your acceptance of their application, that they be given a permit,
Zoning certificate.
a zoning certificate.
Very good.
Bryce?
I second.
Is that,
Yeah, that's fine.
let's do a roll call vote, please.
Mr. Bartold.
Yes.
Mr. Martin.
Yes.
Mr. Price.
Aye.
Mr. Roberto.
Yes.
Mr. Reininger.
Nay. Okay, the motion passes. Thank you very much. Moving on to the next item is resolutions for adoption.
Take it easy.
We're dealing with case number BZA 2014-05. It's an abandoned sign. Let me get my... Okay.
Bye, guys. Yeah, thanks.
BZA 2014-05, abandoned sign, whereas Louis Zettler Jr. on June 26 filed appeal number BZA 2014-05 with Colerain Township BZA pursuant to Article 3.3.2 of the zoning resolution seeking a variance as applied to the property located at 1014 Colerain Avenue, Colerain Township, Hamilton County. Whereas this board has considered all the evidence properly presented and finds that to deny the variance would not result in unnecessary hardships to the owner of the premise in question and would be in keeping with the spirit of the zoning resolution. Therefore, be it resolved that by virtue of the foregoing, the Colerain Township BZA does hereby deny a variance of Article Section 15.6.11 of the zoning resolution, and the sign structure must be removed. Vote, please.
Mr. Bartold.
Yes.
Mr. Martin.
I abstain.
Mr. Price.
I abstain.
Mr. Reininger.
Aye.
Mr. Roberto.
Yes.
The next item is BZA, case number 2014-23. It's a variance for an accessory structure. Whereas Nick Vogeley on July 11, 2014 filed appeal number BZA 2014-23 with Colerain Township Board of Zoning Appeals pursuant to 3.3.2 of the zoning resolution seeking a variance as applied to the property located at 3350 Melody Manor Drive, Colerain Township. Whereas the board has considered all evidence properly presented and finds that to deny the variance would result in unnecessary hardships to the owner of the premise in question and would not be in keeping with the spirit of the zoning resolution. Therefore, be it resolved that by virtue of the foregoing, the Colerain Township Board of Zoning Appeals does hereby grant a variance of section 10.2.3, bracket C of the zoning resolution, subject to the following conditions listed as number 1. Roll call vote, please.
Mr. Bartold.
Yes.
Mr. Martin.
Yes.
Mr. Price.
Abstain?
Mr. Reininger.
Aye.
Mr. Roberto.
Yes.
All right, next item on the agenda is unfinished business. Mr. Mills, any unfinished business?
There is not, I do have an announcement. There are some training opportunities coming up. I think that those got sent out to everyone. As I mentioned to the Zoning Commission yesterday, if there is something that strikes you as, would be interesting to you, let me know. And we have some funds still available to pay for training, so I'd be happy to pay for that.
Okay. Thank you. And that's been emailed to us, I would take it.
Yes, sir.
Okay. Last week. Minutes from the September 24th, 2014 meeting. Should have been on at your place when you came in.
Becky, I know you're backed up. Is there any, you can't get the minutes out earlier? Okay. Yeah, whatever you can. Otherwise, we're just sort of speed reading through them here. I'll move we approve them.
I'll second.
Motion's been made and seconded. Discussion? All in favor? Aye. Administrative matters? Okay. Adjournment, motion to adjourn.
I'll make the motion.
I'll second.
All in favor?
Aye.
Thank you, gentlemen, and staff.